Okay, I think we can start. Okay, greetings everyone. A warm good evening. This is SANDEEP.C, convener for Project Complete Lawyer. For those who are not part of Project Complete Lawyers, those who are coming from the outside Project Complete Lawyer, let me introduce what is Project Complete Lawyer to all of you. So Project Complete Lawyer is an initiative which aims to reduce the incubation time that is required for a law graduate to become a successful lawyer. So our ambition is to reduce the incubation time after graduation to 2 years by developing a systematic approach to providing training with regard to advocacy and lawyering. So in this endeavor was started in 2021, and it's still continuing. And as part of this endeavor, we conduct clinical exercises, and in between clinical exercises, we also conduct academic sessions. Today is an academic session. It is one of the many academic sessions we have conducted throughout our tenure. Today, we will be having the subject Securitization Act, tested on the touchstone of Article 300A, presented by Advocate BIJU ACHUTHAN. He is a practicing lawyer in High Court of Gujarat. He also practices in NCLT Ahmedabad bench. He is a visiting faculty for National Institute of Bank Management, NIBM Pune. He is also working as a faculty in Bank of Baroda Apex Academy and SBI Regional Training Center, Gandhinagar. He is also an author. His recent publication is Malabar Rebellion, a Gandhian Oversight Retrospect, published in 2021. Sir, it's a pleasure having you today with us. From his background, which I have elaborated, all of you might have understood that he is more than qualified to speak on the subject. Hopefully, after the presentation, we will be having a Q&A session and a discourse and dialogue among the participants with regard to the topic itself. Sir, without any delay, I hand over the podium to you. Vijay, sir.
Thank you, Sandeep, and thank you, Johnson. Welcome, friends. As told by Sandeep, myself, BIJU Nair. I am a Malayali who got settled in Gujarat from 1999 onwards. After practicing for a short period in Kerala, I came for a bank job with Bank of Baroda in Gujarat. After 7 years service, I resigned. I was a senior manager law with BOB. Then I resigned and I resumed my practice in Gujarat. Last week, when my friend Johnson is my old good friend, we are classmates and colleagues. When Johnson called me and talked about the prospects of conducting a session on this subject, SARFAICI, our main concern was it's a very barren area. It's a very barren area, SARFAICI, because my experience is as a faculty for bankers for the last many years. What I had realized is other than bankers and the litigants, means defaulters, nobody else is interested in SARFAICI Act or Securitisation Act, and even even in the lawyer community, there may be only a handful of lawyers who are in this area. So, to what extent we can keep the attention of the participants in this session? Then ultimately, what we have concluded is that yes, we can link it with a very interesting topic, that is Article 300A of the Constitution. Then we can keep the enthusiasm of the participants live, and in that way we can go on. So ultimately we have decided that topic, and this title is given like that. And Article 300A and the right to property, because you are all either final year law students or doing further studies, or some may be practicing lawyers, I did not discuss much about that. But the thing is that Article 300A, which is one of the most tumultuous area in the Indian constitutional history, because this, if you study, if you read any book like H.M. Sirvai, then Durgadas Basu, then Vanderbilt Austin, then if, and even the Constituent Assembly debates, we can see that actually this is one of the area, and to the best of my knowledge, this is the second topic which has taken the maximum time for the Constituent Assembly, in the Constituent Assembly debates, because of the, without saying, there was a rift between Govind Vallabh Pant and Sardar Vallabhbhai Patel, and it was consumed a lot of time. And in what I have gathered is that rift continued even after the framing of the constitution, and coming into force of the constitution, and continued throughout the history of the country. So, and of course, that is, it just always has the linkage with the political ideology of the people. Then, if you see the opinion of two of the eminent constitutional jurists of our country, one is H.M. Sirvai and Durgadas Basu, they were very much concerned about the taking away of article, this right to property from the chapter of fundamental rights, and giving the status of a constitutional or a legal right. And it is actually interesting to know that Dr. Durgadas Basu, in his classic work on constitutional law of India, which is running into, I think, if I remember correctly, 30 or 32 volumes, even Durgadas Basu even expressed the concern, and even he has gone to the extent of saying that even the constitution of the erstwhile USSR, and even the 1986 or 88 constitution of the People's Republic of China guarantees a better right to property to the citizens than the right to property which is available after the 44th Amendment. And H.M. Sirvai was also, in his classic work, he raises pertinent questions about the 44th Amendment and the intention of the state in taking away the right to property from the spectrum of fundamental right and giving only a constitutional right status. He raises certain pertinent questions. Because by 44th Amendment during the Janata government has taken away or deleted Article 19(1)(f) and 31, and gave the status, and placed it in the form of Article 300A under a separate chapter, and a chapter with a single article for right to property. But H.M. Sirvai raises certain pertinent questions. The questions are like this: you guarantee me the right to life and liberty. How would I pull on my life without having the property? Then you give me the right to travel anywhere in India and reside anywhere in India and settle anywhere in India. How would I live without having the property? You give me the freedom of speech and expression, and then how I would express my rights through a press? If I want to run, I want a newspaper, I want an office, I want a roof. How I will do that if I am denied my property rights? And you are saying that I am having the right to practice my profession, work, and carry on my business without property. And if I want to run a factory or I want a small unit in which there is a lathe machine is to be installed, all the property include movable and immovable properties. If I am having no right, which is very fundamental, on those properties, how would I do that? How would I enjoy my right to life without these rights or properties? So that policy itself was wrong. That is the strong view of H.M. Sirvai. And Durgadas Basu was also of the view that you are giving, even after you have removed the fundamental right status of right to property for ordinary citizens, you are giving the fundamental right status of right to property of minority institutions and agricultural class. Durgadas Basu raises a very pertinent question. What about the majority citizens? They did not have a right to property. Then another question is, there are many poorer people who are poorer than agriculturists, who are from slum dwellers. What about their right to property? So those things are unattended. And Durgadas Basu even expresses the disgust over this development, saying that ultimately it is the call of the legislature and they have to decide it. But unfortunately, the thing is that what I'm saying is my viewpoint only. You don't take it wrongly. The thing is that all political parties are of the same view more or less of the same view, and for the people who have introduced, because after 1950, once the constitution came into force, after that it was continuously being amended. The first amendment, fourth amendment, 17th amendment, 15th amendment, then 24th amendment, 42nd amendment, and 44th amendment. All these amendments pertain to right to property only. And every time they were coming forward with a justification that is actually due to the interference of courts. Many development measures or welfare measures for the society could not be carried out by the government because of this, because they are always telling that eminent domain, the doctrine of eminent domain and salus populi suprema lex, these two doctrines they are quoting, and they are saying that because of the judicial interference it cannot be done. So then it is to be taken away, and this is the thing. And but actually, if you thoroughly go through the constitutional history of India, you will realize that it is not like that, because the first amendment happened in 1951. At that point of time, if you see the judgments of the Supreme Court, if I remember correctly, Kameshwar Mishra versus State of Bihar and Chiranjit Lal versus Union of India in 1951, there were two judgments. Those judgments were in favor of government, and it was not like that. But and Durgadas Basu incidentally says that immediately after the death of Sardar Patel, 6 months after the death of Sardar Patel, Jawaharlal Nehru came forward with this amendment. Then first amendment, but slowly, I should say that our judiciary was watchful enough to understand the way in which the things were going on, and they rose up to the occasion at many instances, not in all, but in many instances, and they came out with at least some judgments which gave relief to the citizens. And in that, Bela Banerjee's case is there, then Kochuni versus State of Madras is there, then ultimately, in 1973, the classic Keshavanda Bharati came, in which even though the law was protected, the particular Kerala law was protected, the basic structure doctrine propounded by Nani Palkiwala became the what we can say that acquired one of the flagship constitutional principle of our jurisprudence. So then, but even after 1973, then in Keshavanda Bharati, Supreme Court held that you can amend the constitution, but you cannot disturb the basic structure of the constitution, and the fundamental rights and judicial review forms part of the basic structure. Okay, the government or the state found the easy way. If you cannot change the basic structure and disturb the fundamental rights, let it cease to be a fundamental right. So they have removed it from the area of fundamental right and kept it as a constitutional right. But even after that, in the well-known bank nationalization case, Cooper versus Union of India, then Minerva Mills case, and I will show the slides for that. And subsequently, till even in 2021, there is a beautiful Supreme Court judgment which is linking Article 300A with the Article 21 of the Constitution of India. So slowly, in the beginning, we can just have a discussion about this thing. Then we can enter into the area of SARFAISI Act. Okay. So I am not taking much of the time. So these are all the concerns expressed by H.M. Sirvai about, because in his opinion, actually this 44th Amendment was enacted without much deliberation on the subject, and even without referring it to a select committee of the Parliament. So he was expressing his disgust on that. Then this is one judgment, Delhi Airtech Services Private Limited, in which the Supreme Court arrived at the finding linking it with the right to life and liberty. It is accepted in every jurisprudence that by different political thinkers that some amount of property right is an indispensable safeguard against tyranny and economic oppression of the government. Jefferson, he was referring about Thomas Jefferson, was of the view that liberty cannot long subsist without the support of property. Property must be secured, else liberty cannot subsist, was the opinion of John Adams. Because Supreme Court was referring about the founding fathers of US Constitution and framers of the US Constitution. Indeed, the view that the property itself is the seed bed which must be conserved if other constitutional values are to flourish is the consensus among the political thinkers and jurists. Then recently in 2020, I'm not discussing all the judgments in the course of history. Then recently in 2020, Supreme Court of India through Justice S. Ravindra Bhatt held like this. It is therefore no longer open to the state in any of its forms to claim that the law or the constitution can be ignored or complied at its convenience. The decisions of this court and the history of the right to property show that though its preeminence as a fundamental right has been undermined, nevertheless, the essence of the rule of law protects it. The evolving jurisprudence of this court also underlines that it is a valuable right ensuring guaranteed freedoms and economic liberty. The phrasing of Article 300A is determinative and its resemblance with Article 21 and 265 cannot be overlooked. They, in effect, are a guarantee of the supremacy of the rule of law, no less. And the Supreme Court even says that permitting the state, whether union or state government, to assert that it has an indefinite and overriding right to continue occupying one's property, whatever be the pretext, is no less than condoning lawlessness. Then this is a judgment which I was referring about, which was authored by Justice Sanjay Kishan Kaur, and it was a 3 members bench. Right to property is still a constitutional right under Article 300A. Please note here, actually, even though it's not a fundamental right, it's a constitutional right, and the Supreme Court, the highest court, was trying to draw a line of similarity between these two provisions and to give a nexus between these two things, because within the limited available scope of law provided under law. So right to property is still a constitutional right under Article 300A of the Constitution of India, though not a fundamental right. The deprivation of right can only be in accordance with the procedure established by law. Though there may be a process provided for redressal under the scheme of the Act, it is the very scheme of the Act which has been breached by the respondents herein in not complying with the statutory provisions. Now, this Delhi Airtech Services Private Limited already I discussed then. Now, so this is how Supreme Court has dealt with the right to property at different points of time. Now, we are entering into the area of SARFAISI Act. SARFAISI Act, since even yesterday some session has been taken by somebody, some expert, you must be knowing. SARFAISI Act, actually, this is a statute. You must be knowing, actually, till 1993, the bankers were also treated as like ordinary litigants as far as recovery of money is concerned. In 1993, on the basis of Narasimhan Committee recommendation, one law was enacted. It is called Recovery of Debts Due to Banks and Financial Institutions Act. Now it is renamed as Recovery of Debt and Bankruptcy Act 1993. By that law, a new instrumentality called debt recovery tribunals were established throughout the country in 1993 onwards. But 1993, from 1993 till 2002, when we reached 2002, the government realized that this DRTs and the Recovery of DRT Act, that's the Recovery of Debts Due to Banks and Financial Institutions Act, also became more or less a white elephant because of the procedural issues and all those things. Then that is actually the reason for the evolvement of the concept of Securitization Act, in which one party is devoted for enforcement of security interest. And you please remember, the main difference between these two things is, one is DRT Act over civil suit under the CPC, that is available for recovery of money from the defaulters in different methods, not only against the available securities, even if there is no security at all. Suppose I am taking a loan without any security, the bank can file a suit against me in my personal capacity, and they can attach my personal property and sell it after getting a decree. But in the case of Securitization Act, it is not like that. Securitization Act provides for a remedy against the security. That is, they call it as secured asset and security interest. So that is available only available the security. Security may be in different form like hypothecation or mortgage. And against that, you can enforce the your right by through the various provisions of Securitization Act, especially Section 13. Now, you know, Section 13 it is it's a more long section. Section 13. First point is that it should be the account, the particular loan account should be a non-performing asset as per the RBI guidelines. Then you have to issue the notice, and then the 60 days notice you have to give, the bank has to give. And if the borrower is not paying within 60 days period given in the notice, borrower and guarantors, borrower includes guarantors also, then the bank can take the steps under section 13(4). Now you see, now here, from here onwards, actually 13(2) is actually forms the basis, the foundation of the SARFAESI Act measures, which is in the form of a demand. By a notice, bank is making a demand, bank is giving 60 days time, borrower is getting 60 days time, and if the borrower does not make the payment during that period, then bank can start the measures under section 13(4). 13(4), there are two components. One is taking possession and then sale. Here only actually the relevance of Article 300A comes. You may dispossess me, and you may alienate my property. These two components are there. So that is why in this areas Article 300A is relevant. Then as far as possession is concerned, there is a procedure prescribed under the SARFAESI Act and the Security Interest Enforcement Rules 2002, like a giving of once 60 days time is over. Then you know the first the flagship case in the history of Securitization Act is Malabar Chemicals. In Malabar Chemicals, actually, immediately after the enactment of the SARFAESI Act, in the Malabar Chemicals, the borrower, that is the Malabar Chemicals, is a company in Gujarat. They approached the Supreme Court, and Supreme Court stayed the operation of the statute for some time, and Supreme Court also came out with certain suggestions. One suggestion was that actually there was no remedy. There was a provision for appeal, but there was a condition of deposit of 75% of the part of the demanded amount. Supreme Court said no, that is discriminatory. When that is a first forum or first quasi-judicial forum to be approached to redress my grievance, how you can ask the borrower to deposit this money? So Supreme Court said no, that should not be. So thereafter, this new provision has been inserted that actually after 13(2) notice is there, then first thing is that the deposit clause is taken away. And one important thing is that after 13(2) notice is issued, if the borrower raises any objection or a representation, the bank should, it's a mandatory provision, should reply to that in a substantiating way, not a swaying reply is sufficient. It's in a substantiating way. Then after that, the bank can proceed under SARFAESI. Then possession ke liye, for possession also there are formalities, legal procedural formalities are prescribed, like affixing of notice, issuance by delivery, then publishing in two newspapers, that is English and Gujarati, in vernacular. Then after that, then drawing of Panjanama, and if when you are taking actual possession, preparation of inventory, and once the possession is over, the bank has to take care of the assets, then value it, and thereafter bank can go for sale. In sale also the same type of formalities are there. You have to issue the notice, then affix the property, then publish in the newspapers. And there's a concept of reserve price also. You must be knowing that actually according to the value, and there is a condition provided in the law itself that every valuer cannot do that. Only the valuer approved by the board of directors of the concerned bank, he should value it, he should give the valuation. Then on the basis of that, the bank will fix the reserve price, and on the basis of that, the bank will go for auction. And after 2002, I think twice or thrice Act has been amended, and as per the present position, if suppose in a particular auction it is not materialized, the bank can go for reducing the reserve price stage by stage. And to what extent the bank can reduce, law is silent, but every bank has its own formality. They are having their own committees of executives to decide that. So accordingly, they will do it, and then they will go for sale. This is primarily, this is the superficial structure of SARFAESI Act. Okay. Now, this is one judgment of Supreme Court you should know. That is actually it was in 2009. because we are linking it with Article 300A, this judgment is of very much importance. The Supreme Court has held that this is authorized officer Indian Overseas Bank and others versus Ashok Sawmill. Supreme Court held that the intention of the legislature is therefore clear that while the banks and financial institutions have been vested with stringent powers for recovery of their dues, safeguards have also been provided for rectifying any error or wrongful use. We are unable to agree with or accept the submissions made on behalf of the appellants that DRT had no jurisdiction to interfere with the action taken by the secured creditor after the stage contemplated under Section 13(4) of the Act. On the other hand, law is otherwise, and it contemplates that the action taken by the secured creditor in terms of Section 13(4) is open to scrutiny and cannot only be set aside, but even status quo ante can be restored by the DRT. In many cases, what happens is that property might have been transferred during the pendency of this litigation. Then if the court finds that, so the DRT finds that no, it was unlawful, then as per the Supreme Court judgment, it can be even directed to be given back. Status quo ante can be restored by the tribunal. Now, one concern was that actually, this is having different stages. So first is demand notice, then possession, then sale. One question was originated during the course of events is that, suppose I am challenging sale, I am approaching the DRT only at the stage of sale, then whether I can challenge the possession notice and even demand notice in this. Many DRTs were taking or DRATs were taking different stance. In this case, in these three judgments, one by Telangana High Court, another one is by Madras High Court, and one is by Gujarat High Court, it was held that it can be. Even if the borrower did not choose to approach the DRT when he has dispossessed, but instead does the same when auction notice is issued later in pursuance of the same, then he cannot be non-suited on the ground that 45 days from the first cause of action, that is taking over symbolic possession, have expired. With paras 87 and 89, accordingly, the High Court held that the limitation starts afresh every time. That means when I am issuing a fresh sale notice, actually the limitation in qua the possession notice as well as challenging even the demand notice that arises. So I can challenge even the demand notice and possession notice in the Section 17 application, which I may file after issuance of the auction notice. So that is actually a judgment in favor of the borrowers, and it's a great relief to the borrowers. Then I think to the best of my knowledge, there is no Supreme Court judgment on that point. Now we are coming into one Supreme Court judgment that is actually in this judgment actually regarding, because Section 34 of the SANDEEP.C Act clearly bars the jurisdiction of the civil court. No civil court will not have the jurisdiction to entertain any matter which falls within the spectrum of SANDEEP.C Act. But actually, this judgment, many lawyers and experts are of the opinion that they are having different opinions about the correctness of the judgment. The Supreme Court has even gone to the extent of saying that even the title of on the property that can be decided by the DRT in a Section 17 application. For that, he need not go to a different forum. Supreme Court says that the fact that the stated flat was the subject matter of a registered sale deed executed by the 5th and 6th respondent in favor of the 2nd and 4th respondent, and which sale deed has been deposited with the bank along with the share certificate and other documents for creating an equitable mortgage, and the bank had initiated action in that behalf was indisputable. If so, the question of permitting the 5th and 6th respondent to approach any other forum for adjudication of issues raised by them concerning the right, title, and interest in relation to the said property cannot be countenanced. The High Court had not analyzed the efficacy of the concurrent finding of the fact recorded by the DRT and DRAT, but opined that the same involved factual issues warranting production of evidence and a full-fledged trial. So the Supreme Court observed that the approach of the High Court was completely fallacious and untenable. Then, now we will discuss about 4 judgments. My request is to carefully try to understand these 4 judgments. One is General Managers Deshwara Cooperative Bank Limited and others versus Iqbal. This was a judgment delivered by Justice R.M. Lodha, because actually how these are all the judgments which actually not supports the Article 300A. It is actually, this judgment is going against the spirit of Article 300A. In many judgments, even in Maradia Chemicals and in subsequent judgments, this Ashok Sawmill judgment, which I have quoted some 3 or 4 slides back, says that these are all mandatory provisions. Here in this case, there was no strict compliance of mandatory 30 days period for sale notice. The condition of payment of 25, because actually as per the security interest enforcement rules, 10% at the time of sale, that may be covered in the earnest money deposit, and thereafter 15% within the next working day. That is 25% should be done within the next working day of the sale. That condition also was violated, and the full sale consideration was to be paid within the 15 days period. That also was not complied with. Still, the Supreme Court held that that will not nullify the action of the bank. And even actually Supreme Court has reversed the finding of the High Court. Supreme Court's finding is like this: there is no doubt that Rule 9(1) is mandatory, but this provision is definitely for the benefit of the borrower. Actually, Supreme Court has applied the principle of waiver in this judgment. That is actually, even though this is a mandatory provision, by action or explicit or express or implied action, when the borrower himself waive his right, then there is no need of nullifying the action of the creditor. And similarly, the Supreme Court says, similarly, Rule 9(3) and Rule 9(4) are for the benefit of the secured creditor. And it is a settled position in law that even if a provision is mandatory, it can always be waived by a party for whose benefit such provision has been made. So the provision of Rule 9(1) being for the benefit of the borrower, and the provisions contained in Rule 9(3) and Rule 9(4) being for the benefit of the secured creditor and the borrower can lawfully waive their right. So when the borrower has, in this case, what happened is, when the sale notice was there, then the auction purchaser approached the bank with a compromise proposal. Then he has offered to pay the part amount, and he bought time from the bank. And by doing that, he has delayed the sale process for a considerable period of time. So Supreme Court held that you have waived your right, enjoyed the benefit of the concession given by the bank. So the principle of waiver will apply even if it is mandatory, because you are the beneficiary and you have waived it. But this judgment, when that was there, Supreme Court in 2014, Matthew Varghese, this is a case originated from Kerala. Matthew Varghese case took a totally different stand, linking the rights under the SANDEEP.C Act with Article 300A of the Constitution. Supreme Court held a reading of Section 13(1) therefore is clear to the effect that while on one hand, any secured creditor may be entitled to enforce the secured asset created in its favor on its own without resorting to any court proceedings or approaching the tribunal, such enforcement should be in conformity with the other provisions of the SANDEEP.C Act. Then Supreme Court says, we find that there is a valuable right recognized and asserted in favor of the borrower who is the owner of the secured asset and who is extended an opportunity to take all efforts to stop the sale or transfer till the last minute before which the said sale or transfer is to be effected. Having regard to such a valuable right of a debtor having been embedded in the said subsection, it will have to be stated in uncontroverted terms that the said provision has been engrafted in SANDEEP.C Act primarily with a view to protect the rights of a borrower, in as much as such an ownership right is constitutional right protected under Article 300A of the Constitution. So here, Supreme Court has not referred the previous Iqbal judgment at all, and the principle of waiver applied by Justice R.M. Lotha. Then Supreme Court has nullified the action of the bank, saying that because actually in this case what actually happened is 30 days time the principle of 30 days time has not been followed by the bank. Actually, as per the Matthew Varghese judgment, this judgment, the 30 days period has to be calculated from the last notice. Suppose in the sale notice, actually for sale there are 3 notices. One you have to deliver. Normally bank would do by registered post. Another method is actually by affixing at the property. The third one is newspaper publication. The 30 days period has to be calculated from the last notice. So suppose, for example, 24th of January, 25th of January, you have issued a registered post notice. Then sale notice you publish in the newspaper on 27. and affixing on 28th, and registered post has been has been received on 1st of January, then 30 days time has to be calculated from 1st of January. So the last date of the last notice, that should be the time. So in Matthew Varghese case, that has been violated. So the Supreme Court held that no, that is that affects the mandatory provision and it is a violation of Article 300A. So action of the bank was nullified. Then in subsequent, in a single year, within a span of 3 months, Supreme Court came out with 3 judgments. The next one is Rajiv Subramanian versus Pandyas or others. This is also in 2014. In this judgment also, the Supreme Court has found linkage between Article 300A and SARFAESI Act measures and held that that cannot be overlooked. And then now, after these 2 judgments, the same bench which has delivered Matthew Varghese judgment considered this case, Vasupi Shetty versus Hotel Vandana Palace and others. And the first judgment was authored by Justice S.S. Nijja. This was delivered by Justice A.S. Sikri. And here, borrower filed a writ petition against the first sale and obtained interim order against the bank during the pendency of SARFAESI Act proceedings, and thereafter first sale notice did not materialize, then second sale notice and all. Here also the bank took the contention and the bank actually relied upon the first time. Actually, in the previous 2 cases, in Matthew Varghese and the other case, the bank did not rely upon Iqbal's case, Justice R.M. Lodha's judgment. But here in this case, bank has specifically relied upon Iqbal case, but Supreme Court did not consider that logic and actually distinguished. And Supreme Court has laid down that actually every case has its own facts. Every case has to be examined in its special factual context, and in every case need not amount to waiver of rights. And when there is no waiver, especially when the party himself has agitated the case before the High Court by filing a writ petition, and the question of estoppel or waiver would not come into play. So in this case also, the Supreme Court has not considered its own judgment in Iqbal's case. Held, no doubt that borrower, instead of doing so, took initiative resulting in one-time settlement but defaulted therein, it would merely indicate that borrower was at fault in not adhering to one-time settlement. You see the cardinal difference in Iqbal's case and this case. In this case, Supreme Court says that the OTS proposal, in the Iqbal's case, OTS proposal was submitted, and when defaulted, Supreme Court took the view that no, you bought money, you bought time and delayed the recovery process, so you have waived. Here, the Supreme Court took the view that no, that amounts only to a default on the part of the bank as far as adhering to one-time settlement is concerned. However, by no logic, it could be deduced therefrom that bank was relieved from its obligation not to follow mandatory procedure. So this is actually in favor of Article 300A. Then ITC Limited versus Blue Coast Limited. This is actually an older judgment. Here actually, even while Apex Court recognized the mandatory nature of the statutory provisions, applied the principle of waiver and held that here actually you see after the Madia section 13(3)(a) was introduced in the statute book after Madia Chemicals case. That is, when the borrower raises an objection to the demand notice, bank should mandatorily reply it. In this case, it was not done. But in spite of that, the Supreme Court held that the legislative intention is mandatory, but such provision and that provision is an integral part also. But it is clear that the creditor was induced by the debtor not to take action against them through assurances and promises. So he had given a compromise proposal and killed time, and then on that basis, then when they challenged it before the High Courts and later on it was originated in this case, I think a petition was filed in Bombay High Court and ultimately it reached Supreme Court. Supreme Court held that no, the principle of waiver applies and you cannot take the benefit of that. Then in 2021, it's a very recent, that's only in December, this judgment came by Justice, I think, Sanjeev Khanna. Waiver is here also the principle of waiver is applied by the Supreme Court. The Supreme Court held that waiver is an intentional relinquishment of a non-right. Waiver applies when a party knows the material facts and is cognizant with the legal rights in that matter, and yet for some consideration consciously abandons the existing legal right, advantage, benefit, claim, or privilege. Waiver can be contractual or by express conduct in consideration of some compromise. However, a statutory right may also be waived by implied conduct. Implied conduct, like by wanting to take a chance of a favorable decision. The fact that the other side has acted on it is sufficient consideration. Here, actually, in all these cases which came in favor of the banks on the context of waiver, the bank has acted upon the assurances given by the borrower. In all those cases, in except Matthew Varghese and the other two cases, the Supreme Court took the view that the other side, the fact that the other side has acted upon the assurance of the borrower, that itself is a sufficient consideration. Now we were discussing that about 300A. So these are all certain cases in which I personally feel that the Supreme Court has not done adequate justice to the cause of Article 300 and 300A. This is a recent judgment of L&T Housing Finance Limited versus Trishul Developers. 13th notice is a statutory notice. Statutory notice is very sacrosanct, and even there are judgments to the effect that even a minor difference or a change in the name on the name of the addressee will vitiate the demand notice when it's a statutory notice. 13.2 is a statutory notice. In that, actually, borrower has taken a loan from L&T Housing Finance, and the demand notice was issued by L&T Finance Limited in the letterhead of L&T Finance Limited and under the rubber stamp of L&T Finance Limited. Supreme Court held that no, that is actually a trivial mistake, and the borrower was aware about that. So it cannot be considered as something which goes to the root of the matter, and so the Supreme Court upheld the demand notice and held that that will not be vitiated. But my opinion, my humble view is that I don't know to what extent that is correct. And lastly, there is a recent judgment of the division bench of the Gujarat High Court regarding demand notice. As I told you in the beginning itself, that when we started practice in our beginning years in the profession, there was a concept. Bank's money is public money, and generally the principle is that, or notion is that if a bank files a suit or if bank's action is there, that will not be nullified by the court. Such a notion was prevalent. But now that is not the position. After 2002 and after the span of around 10, 12 years or 20, 15 years, then the scenario has changed. Now the thing is that the courts are examining the action of the banks in the context of Article 300A. In this Supreme Court, in this division bench of Gujarat High Court judgment, Mithilanchal case, what actually happened is the bankers issued a demand notice. Banks have the tendency to issue in a very ritualistic way demand notice, in which they, because the law section 13.2 says that the notice should contain the details of the debt demanded. So what this mean by details? The division bench of Gujarat High Court held that details means you should give the bifurcation, you should give the rate of interest, you should give the date of NPA, you should give the details of secured assets. All those things are there. So when during your practice you will come across the notices, or if now you can examine it. Many 13 notices issued by the banks are issued in a very ritualistic way without any bifurcation of the details. You are making a demand to me. Even many cases we are coming across notices in which even the rate of interest are not mentioned. Then how would I come to know at what rate I should pay the my debt? So that is very important. So the division bench held that would vitiate the notice. But of course, there are, I don't know, I think the appeal is pending before the Supreme Court, and what stand the Supreme Court would take, whether just like L&T Housing Finance, it would be taken as a very trivial objection, or in whatsoever manner they would take, I don't know. So these are all in nutshell my viewpoints about the Article SANDEEP.C Act in the context of Article 300A of the Constitution. So now the forum is open for your queries.
Thank you, BIJU sir. Wonderful presentation, nevertheless.
Thank you,
The
sir.
complex subject which had to be presented in a very short time. You have done your best, and I'm very sure that the questions are there from the participant side. So the floor is open for question and answer session. And before raising the question, kindly identify yourself. So, anyone?
So,
Aravind, yes.
good evening, Vijay. So, my name is Arvind Prakash, and I'm
Ye-
currently pursuing fourth year of BCom LLB from School of Legal Studies, CUSAT.
Okay.
So, my doubt is regarding the relation between IBC and SURF-AC Act. So, can I proceed?
Yes, you may.
So, as mentioned in section 238 of the Insolvency and Bankruptcy Code, which deals with a non-obstinate clause, by giving provisions of the IBC and overriding effect over any other provisions of law, including the SURF-AC Act. So, since there is a apparent conflict between these statutes, it eventually lead to multiplicity of proceedings. And could you share the reason why IBC is preferred over the SURF-AC Act for recovery of debts? And there are many decisions with regard to this.
No, my viewpoint is that actually, first of all, IBC as such is applicable as far as implementation is concerned to the corporate borrowers, and it has not yet been applied in the case of partnership firms and individuals. The parts dealing with that, and the intention is very clear. The intention behind introduction of behind the introduction of IBC is very clear. The debt should be resolved. Every businessman or every person who has taken in the case of IBC as it stands now, every corporate borrower should be given a chance for resolving his debt. So either the purpose of IBC is not at all the recovery of debt. Normally, we are having a belief that it is also a forum for recovery of debt, but it is actually a forum for resolution of debt. So then naturally, the tendency would be that it should be given preference and priority. So that is the logic behind that. So a person should not be compelled to close down his unit or should be in the street even without giving means corporate person. I am saying should without giving a chance for resolution of debt. That is why even if suppose the financier the financier feels that yes he should be given a chance, he can approach under section 7. If an operational creditor, a financial creditor is having the right under section 7, then then an operational creditor can approach the NCLT for resolving his operational debt, and even the borrower himself can go. So all the stakeholders, because if you see the object clause of IBC, you can see that the intention is to protect the interest of all the stakeholders. So all these persons can approach the IBC to resolve the debt. So that is the purpose. So then naturally it is given priority. So that is why the law says that once the matter is admitted before by the NCLT, then no coercive measures should be taken against the borrower.
Clear, sir.
Can you give some insight regarding the jurisdiction of the High Court insofar as interfering with the proceedings under Section 13 of the how far it can and how far it shall not? Now, what is the latest position? In some cases, the High Court was
Yes.
interfering.
Johnson, actually, it is actually as an advocate who is appearing for both sides. It's a matter of concern for us because actually what happens is in many cases the DRTs are passing non-speaking orders. You know what happens is when there is an alternate remedy is there under the DRT Act, there is an alternate remedy of approaching the remedies provided under Section 17 to approach the DRT. Against that, you can approach the order of the DRT, you can approach the DR80. The biggest problem is, as far as DRT is concerned, court fee is there. And a court fee, of course, there is a ceiling of 1 lakh rupees is there. But for a borrower to approach against an order of DRT to the DR80, the condition is that he should make a deposit of 50%. Actually, this is a very stringent provisions, and I have seen people who are literally crying in the court, saying that where we would go. And the fact was that they did not even receive the demand notice. It's a fact. They did not even receive the demand notice, but the tribunals have taken a stand that actually public money, you have adopted delay tactics and all. But the thing is that the law is law, and the mandatory provision, when you are taking away or disposes, I am not demanding anything else. I am only demanding that you should comply with the statutory provisions. So that is there. So what I feel is that actually when these type, because actually of course Article 227 is Article 226 and 227 is much wider than Article 32 of the Constitution. And just like an erroneous exercise of jurisdiction, lack of exercise of jurisdiction is also an issue in which the high courts can exercise the discretionary jurisdiction. So in such cases, what I feel is, if a non-speaking order is passed or a particular aspect has not been examined by the DRT, like that, the high court should interfere. But actually, as you asked me that query, I am telling that high courts are very reluctant, because now what happens is none of the DRITs are functional. All the 4 DRITs are not functioning because of the non-post appointment of chairpersons. So high courts, as per the direction or as per the request of the Supreme Court, high courts are entertaining. But otherwise, high courts, some judges are of the view that no, we can interfere, but most of the judges are very reluctant when this is there. And even 13 to notice, if there is a defect in the 13 to notice, if you are directly approaching the high court will not entertain it. High court will tell you, give a reply. And 13-4 step, when you taken, you are having the remedy of approaching the DRT. But what actually the problem is, nobody is realizing the financial aspect involved in that. For a borrower who is already bankrupt, or who is already in the street, for him 1 lakh rupees or 50,000 rupees and advocate fee of another 50,000, 1 lakh, or in Bombay and all, it may be running into 2 lakhs, 3 lakhs, 4 lakhs, then it is very costly. So those things are there, but unfortunately this is the position. So writ jurisdiction rarely only high courts exercise.
What is the position insofar as IBC is concerned when, suppose there is an IBC proceedings and there was no resolution at the first place, and there is also some secured assets? What will happen for the financial creditors who are having secured assets?
No, the thing is, if the resolution does not happen, they can go for liquidation, or otherwise they can go ahead with the recovery measures. Both the avenues are open. So that
financial creditors can go for both.
After that, because when the moratorium is there, it can, but if it is not working after that, it can go ahead with that.
They need not distribution the samayathu prashna.
Yes, at that point of time, if against a corporate borrower you cannot go ahead, but against the guarantors you can. Personal guarantors or corporate guarantors against whom you have not initiated insolvency measures, you can go ahead. That is there.
So is there any other questions from the participant? Sir, from what I understand from your presentation is you are not at all pleased with the current direction in which the judiciary is interpreting the provisions, right?
To a great extent, yes, I should say that.
Yes, from your presentation, what I can understand is the right to property as a legal right itself is increasingly diminishing.
Yes.
And increasingly the judiciary is supporting the financial institutions.
Yes, actually the thing is, what happens is the label of public fund and public money that is there, and that protects the banks. That's
I understand. Under that pretext, they hide behind that pretext.
Actually, yes, you used the correct word. Actually, because of that, in that pretext, actually the banks are taking it very lightly, and they're saying that it is public money, so we want our money. Okay, law does not say that you need not recover your money. Law only says that you follow the procedure. And it's a question of, you see, 60 days plus 30 days or 40 days or 45 days or 60, 120 days ka, the issue of 120 days only, maximum. Just I'm making a rough calculation. 60 days plus after that's for say possession. After possession, say for the sale in the first instance 60 days, subsequently 15 days is sufficient. So the thing is that even for following this, actually, if they are maintaining a checklist and doing it, I used to advise all my banker colleagues, saying you maintain a checklist, and if you are doing all these things and everything you are taking, then there will not be any stay at all. But the stays are coming from DRT because of the faults on the part of the banks, because they are not following these mandatory provisions. But the problem is actually it depends largely upon the presiding officers of the tribunals and the concerned judges who are dealing with this. And they may be tempted to carried away by the, as you told, the public money and public fund recovery and all those things in recovery of NPA.
Using the argument between public interest and private interest, right?
Yes, actually, I'm not even saying that public interest and private interest. I am actually not agreeing with that expression also. You see, actually, when somebody is violating the law and do it for a public cause, that cannot be, I would not agree that that is for public cause. It is actually what the law says. You do this is a draconian law. You cannot overlook that aspect. This is a draconian law. Actually, Sandeep, you will realize the heat of this provision only when we are at the receiving end. I have seen many families having children studying in the third year engineering, fourth year medicine, and you may not believe, during my experience as a senior manager law in 2004 or 5, after the stay is vacated, banks were very much enthusiastic for recovery. I went along with the authorized officer of the bank for a recovery. That was actually a house. It's a beautiful 2-4 building, belonged to a Punjabi, a Sardarji. I went there with the authorized officer and another officer of the bank. That person, that gentleman, he was actually crying, and he told me, please, only one request. I admit that I have defaulted. You have given me the notice and everything. My daughter's examination is going on. If you are asking me to vacate now, I will vacate it. But we have to take a house on rent, and that will disturb my daughter's life like anything. Please don't do it. But authorized officer was not budging. He was not ready for conceding to the demand of his father. Ultimately, what happened is, actually, I was heading the legal department of that zone. Though I telephoned to the zonal head, and taking out of the way personally, after taking personal interest, I requested the zonal head. And that DGM or general manager was actually from Rajasthan. He was from Rajasthan. He was kind enough to say that, okay, you do one thing, you get a letter from the party saying that after 15 days, 20 days, whatsoever days he wants, he will vacate it. And the gentleman was so nice that immediately he has given the letter. And I still treat that actually that was a day on which I have done something good. So these things are there.
Okay, sir. Another thing that came to my mind throughout your presentation is, you were saying that the banks were not following the procedure with regard to the notice period and all. I have to ask, and pardon me if I am putting this question in a wrong way, whether the banks are doing it by design or by whether it is by negligence on their part. What is preventing them from following this time period? The procedure of time.
I should say that actually they are casual. The thing is that the seriousness with which they are raising the question to us, why the DRT has given the stay, it's a public money, why you did not argue that it's public fund and 5 crore rupees is blocked, why the DRT is not considering that? We are replying that why you did not consider this aspect while issuing a notice like this. This is your money, or this is people's money for which you are the trustee. You are handling that money. While handling this money and while trying or while taking the measures for recovery of this money, if you have not complied with the statutory provisions, not bothered, or you have not adopted the methods with the seriousness it required, how you can expect that the court should be concerned about that? So you are partially correct. it is due to, I'm not saying that by design they are doing it. Maybe there may be people who are doing it internally, but by and large it is because they are not realizing the seriousness. And
yes. Sir, please continue.
and the banks should, especially big banks, should develop its recovery mechanism by appointing more law officers in their recovery cells and recovery branches and all, and experienced law officers, not the, I should say that actually not campus securities, people who are having 1 or 2 experiences, lawyers and all, they should recruit in scale 2, scale 3, scale 4 and all. There may be 2-3 law officers for every recovery cell, and because they are aware about the judgments and all, and when you are issuing a demand notice, they will go through it, they will scrutinize it. In every possession notice, their eye will be there. So then naturally banks' interest will be protected. But somehow the banks are not doing it, to be frank. And if a law officer is posted there, they will dump entire work upon them, starting from Right to Information Act and labor issues and consumer issues. They will ask him to do these works also. This is why it is happening. You must be knowing. I mean, Johnson has asked.
Yes, sir.
How and Nirmala Sitharaman was claiming and boasting about IBC, recovery through IBC. Both are totally different. It is not a coercive measure, IBC. So that is why it is happening like that. And in the case where the coercive measures are there, your recovery is nothing through DRTs or through surfacing.
Understood. So we will be winding up the session. Is there any other questions? One more. Is there any? Okay then. It seems there will be no question, and we have already exceeded our time. Thank you, BIJU sir, again. Thank you so much for being with us, spending your valuable time and sharing your experience, your wisdom, and your knowledge with regard to the topic itself. As Johnson sir mentioned earlier, this is a new topic that the students of PCL has been coming across, because unfortunately the syllabus that is followed in many of the universities in Kerala are not up to date with the recent developments. And I believe they have got a new perspective on the recent developments with regard to securitization and its challenges and opportunities, I believe, very well. I also thank Johnson sir, who has also very much influential in organizing this event. I thank all the participants for joining us, the members of PCL as well as those who are from outside. Thank you all for spending your time with us. Hope to see you soon on another academic session.
Thank you, Sandeep. Thank you, Johnson, and all the participants.
അല്ല ബിജുവിനെ പറ്റിട്ട് ഒരു കഥ പറയാണ്ട് വിടാൻ പറ്റില്ല. ബിജു ആൻഡ് റിസ ഞങ്ങളുടെ ക്ലാസ്സിലെ 2 ബാങ്കേഴ്സ് ആണ്. Biju has left the bank and Riza is still continuing in this SBI. ഇവര് വലിയ ക്വിസേഴ്സ് ആയിരുന്നു. ഒരിക്കലും ക്വിസിന് പോയിട്ട് ഒരു പാർലമെന്ററി ക്വിസ് എന്ന് പറയുന്ന ഒരു പ്രോഗ്രാം ഉണ്ടായിരുന്നു. ഐ തിങ്ക് ഇറ്റ് വാസ് ഇൻ 90 തവണായിരുന്നു. ആൻഡ് ഫൈനലിൽ ദേ ചലഞ്ച് ദി ഒരു ക്വസ്റ്റ്യൻ ചലഞ്ച് ചെയ്ത് ദേ മെയ്ഡ് ആൻ ആൻസർ. അത് അന്ന് ദൂരദർശനേ ഉണ്ടായിരുന്നുള്ളൂ. ദൂരദർശനിൽ ടെലികാസ്റ്റ് ചെയ്യായിരുന്നു. And I remember that they were challenging the question, and finally their challenges were upheld more than twice. രണ്ട് question they challenged, and the answers were went for researchers this thing, and finally found that their answers are correct, and they got the first prize. അന്ന് എനിക്ക് തോന്നുന്നു പാർലമെന്ററി ക്വിസ് ആദ്യമായിട്ട് നടത്തുമായിരുന്നു.
Yes, that was the first time.
അങ്ങനെ ചരിത്രം സൃഷ്ടിച്ചിട്ടുള്ള ആൾക്കാരാണ് ബിജു.
അത് നാഷണലി ബ്രോഡ്കാസ്റ്റ് ചെയ്തായിരുന്നു അല്ലേ?
Yes. That was in 90. There were twice, I think 90 and 91.
Oh, I see. That was the time when I was born, I guess.
Yes.
I see.
അപ്പൊ അങ്ങനെ വളരെ പ്രത്യേകതകളുള്ള ടീംസ് ആണ് ബിജുവിന്റെ ഒക്കെ കഥ പറഞ്ഞത്.
Biju sir, hope to see you again with another session. Hope to see a collaboration with you in our coming event.
Definitely.
Thank you so much.
Thank you, sir. Thank you, Joe. Thank you.
Thank you, Biju.
Thank you, everyone. Good night, everyone.